attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the second segment in a multi-part lawcast discussing Regulation A+. On March 25, 2015, the SEC released final rules amending Regulation A. The new rules are commonly referred to as Regulation A+. Tier 1 of Regulation A+, which does not preempt state law, allows for a raise of up to $20 million in any 12-month period, and Tier 2, which does preempt state law, allows for a raise of up to $50 million in any 12-month period. Issuers may elect to proceed under either Tier 1 or Tier 2 for offerings of up to $20 million. Tier 2 offerings require additional disclosures and ongoing reporting requirements. In the last segment, I discussed eligibility requirements for both Tier 1 and Tier 2 offerings. Today, I am touching on marketing and advertising of the offering. All Regulation A+ offerings will be allowed to engage in general solicitation and advertising, at least according to the SEC. However, Tier 1 offerings are still required to comply with applicable state law, and state law related to general solicitation and advertising, including any prohibitions related to same. Regulation A+ allows for pre-qualification and solicitation of interest in an offering, commonly referred to as testing the waters. All solicitation material must be submitted to the SEC as an exhibit to the Form 1A. Issuers can use test the waters solicitation materials both before and after the initial filing of the offering statement. In the event that materials are issued after the filing of an offering circular, the materials must include a current preliminary Form 1A or information on where a copy can be obtained. Test the waters solicitations may be made both orally and in writing. Unlike testing the waters by emerging growth companies that are limited to QIBs and accredited investors, a Regulation A+ company could reach out to retail and non-accredited investors. After the public filing, but before SEC qualification, a company must use its preliminary offering circular to make written offers. Of course, all test the water materials are subject to the anti-fraud provisions of the federal securities laws. The new rules are expected to be effective on or near June 19, 2015. Details determine diligence when selecting a securities law firm or an experienced OTC attorney, so be sure to seek out the best possible legal representation before initiating a Regulation A+ offering, or any offering for that matter. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.